Well, a very hearty welcome, Sparsh. On behalf of all of us at the university, delight is to know that you happen to be one of our student, favorite students of our director, Institute of Engineering and Technology, Dr. Goel, which is a real pleasure for all of us. And you having immediately after your graduation plunged into the world of patents and patenting, and now having made your career and contribution in that area is amazing in more ways than one to each and every one of us. Let me tell you very honestly, maybe Sanjay would not say so, but I can tell you we are struggling in that area and we want your help. How do we motivate? How do we excite people, so that they take up this cause in a sincere, serious, and religious manner? When I used to talk to a teacher in the area of law, so all I requested him, don't tell them something related to law which will scare them. Tell them always law is your friend, and then they may try to understand the nuances. Similarly, I request and urge upon you, Sparsh, tell them, yeah, this is the way forward if you want to get your work recognized, if you want your work to be understood and appreciated, not only by you, your colleagues, your peers, but the world around, right? This is the area which has taken countries to places, which has
Right,
taken institutions to places. Otherwise you may be doing wonderful work in your own cocoon. Who cares? Who bothers about it? So getting it patented and getting it out is the best way. Number one. Number two, if you can also tell them it doesn't have to be a rocket science idea that you are looking for a Nobel laureate right away. A small little jugaad in any situation can help you do the work for you. Howsoever small, howsoever beautiful, but it has to be having an element of innovation in it. Is there that innovation element in it? Is there an idea in it which is being untouched and not tapped? So these ideas are not to be a rocket science again, as I said. These are to be small little things. And the way this COVID 19 has unfolded itself, it has put many, many kind of some challenges for the students and faculty in all areas, particularly in the areas of engineering, science, and technology. People look, people are appreciative of the problems. People look for solutions, and they don't look at big solutions. They look at small little solutions. So if you are aware what the kinds of problems people are experiencing, the very fact that you are aware these are the problems, I'm sure you will have in your mind there is some solution. Why did you work towards that solution? The very fact that you understood there's a problem, to me, half the problem is solved if you understand what the problem is. So if you not understand the problem, then definitely there is no solution for it. So if you have understood, identified, appreciated a problem, you have a solution in mind. Just wake us up all, including me, on these lines so that we get into the world of patents, because we are a university just 10 years of age, young but vibrant university, looking into this world and many other areas, right?
right.
So that is what I have to say before the formal organizers organize the session. But just my opening remarks, extending a very hearty welcome to you, Sparsh, on behalf of all of us at the university. Look forward to very exciting, engaging, motivating more than anything else, motivating session uh, from you, because our students will be a lot more able to relate when Sonal will tell them Sparsh happens to be the student of our director, Institute of Engineering Technology. That is what is plus point with us, and that will motivate our students, that will motivate our faculty, and that will motivate also me a great deal. Okay, over to Sonal.
Thank
Thank
you
you
so
so much.
much,
Thank
sir,
you so
for
much.
setting up the context, and we have always been overwhelmed by your welcome. I welcome you, Sparsh, at this session, much sought after session of intellectual property rights. Uh, let me take this opportunity to introduce you to our audience, which comprises of industry professionals, faculty members, students of BTech, MTech, even MBA. Few MBA students have registered for it. Mr. Sparsh Arora has been working as a patent analyst and specialist since 2013 after completing his BTech and MTech in CSC from JIT Noida. He has so far drafted 70 plus patent applications and prosecuted 200 plus cases. In the process, he has reviewed and analyzed more than 1 lakh cases He has also completed an advanced course in patent drafting from the World Intellectual Property Organization. What mesmerized me was actually very short duration of his career, he has been recipient of 4 awards: Honeywell Achiever Award for IP Analytics Team by Honeywell, Star of Quarter Intellectual Property Research Team Award, Best Performers Quarterly Achiever Award by CPA Global, Microsoft Patent Research Services, and Pursuit of Excellence Award. We welcome you at this forum, Sparsh, and now this all dice is yours.
Thank you,
And
Sonal.
say, Sonal, what I meant you to say when he is
Sparsh Arora has been student of our respected director, Dr. Sanjay Goyal, and I don't need to mention that actually we have been fortunate enough to listen to many of his students. So by now, and as soon as we share to our students, this session is by student of Sanjay sir. By default, don't need to market anymore amongst my community.
okay. The
That's
only
how
thing,
it has been.
the only thing that when students of our university, particularly from the Institute of Engineering and Technology, see a student of our director is reaching and has reached heights, so
Yes.
they get confident, they get motivated that if Sparsh like students of Sanjay could reach this level, there's no looking back for us. We can also.
Right. So yeah, thank you, Rena sir, and thank you, Sonal, for this wonderful introduction. Even I myself feel very privileged, that I got the opportunity to study under Sanjay Goyal sir. I especially, I studied some subjects under him, and it was truly a different, wonderful experience. I would say, not like the mainline faculty which we generally see. He made me think very much critically about a lot of things. So yes, so I completely second your thoughts on that. So, and to your point, Rena sir, like the objective of this session is pretty much what you asked me to build, which is like encourage students, even faculty members, to how to think about whether they can go ahead and think in terms of patenting something, their idea. So that is the whole objective of this session, and I am sure that by the end of the session, you would feel that we have sort of met the objective.
Right.
So without taking much time, I think I'll share my screen and I'll straight away go to the content. Just let me know, Sonal, if you are able to see the screen.
Yes, we can.
All right.
Convert it to slideshow. Yes, now it is.
Okay. All right. So yeah, today's topic is about patent thinking for innovators. So the agenda of today's meeting would be, I would give some basic idea about what are intellectual property rights, and particularly within intellectual property rights, what is a patent, what are various things which are related to patent, what are the patenting systems which we can use to actually file a patent application. And then the other half of the session would be towards patent thinking, like how a faculty member or how a student can think, whether I can file a patent application on my idea, and what all factors I have to consider when I really think of filing a patent application. So the first half of the session would be to establish a basic understanding of the patent as such, because I feel that a lot of people don't even are aware about patent field, or if they are aware about patent field, there is a lot of confusion. So just to clear out on those things, I'll first go through the basics of patent and then probably towards thinking in terms of patent. Okay, so intellectual property rights. So it's intellectual property rights is a type of legal right. What is a legal right? A legal right is nothing but something. It's a claim which is recognized by law or a statute, which somebody can claim. So rights could be of different types. So for example, there are tangible rights and non-tangible rights. Now a tangible right could be a right which you can assert on a tangible property. So for example, if you own a house, or if you own a building, then you have property papers for that, and those property papers or the lease agreement are the tangible rights. But what about non-tangible rights? What about things which are non-tangible? What about an inventor who has invented something, who has an idea, who has invented a new algorithm, who has invented a new product, who has invented a new technique, which somebody cannot touch maybe, but it is an intellectual thing. So how can you protect that right? That protection is basically provided by intellectual property rights. Now, intellectual property rights are of different types. Patents is one of that type. So patent is a non-tangible right which is provided for any of these things. It could be for a new product. When I say a new product, it could be for a component of a product. It could be for a full product itself. It could be a functionality of a product. It could be a process which is not a product. It could be an algorithm that somebody has written, but it can be implemented in a product. It could be an article of manufacture. So patents are more towards functionalities. So always, whenever you think about what is a patent, it is always talking in terms of functionality, not in terms of anything else. Now, the other type of IP non-tangible right protection which could be there is like copyrights. So copyright is also a type of intellectual property right, but it is for a way of expression. So for example, if a music composer composes some music, so how he can protect his intellectual property? For that, there is a copyright. Then like storytelling or a movie script. This is also something which somebody can protect in form of a copyright. Then even a software code, somebody can protect his way of writing the software code in terms of a copyright. Then this is the another type of intellectual property right. The third type of intellectual property rights are geographical indicators. So for example, if you talk about Darjeeling tea, I mean, it is any product or it is something which provides uniqueness, which is linked to a location. So that is a geographical indicator. So if you see, silk from Mysore is very famous. So they have a geographical indicator on that. Similarly, Scotch whiskey has a geographical indicator associated to it. Swiss watch has a geographical indicator associated to it. Then another type of intellectual property right is licenses, which is generally like open source licenses. We today live in a world where a lot of things are being developed using open source software. So there are open source licenses. There are many open source licenses which are available. Some of them are like MIT license, GPL license, any Android or Linux application we use these days. We use a lot of open source content, and then there are licenses associated to it. And the last type of intellectual property rights is trademarks, which is particularly like logos, watermarks, company names, slogans, products. You can see some examples over here, like McD has its trademark of this symbol. Apple has this symbol as a trademark. Even a slogan like "Just Do It" of Nike has a trademark. Now for this session, the whole focus is only limited to patents, but I just wanted to give an insight about that patent is a subset of intellectual property rights, which is a very, very wide domain. So before I move into actual patent related stuff, there are a few points which I wanted to mention. I believe that there are some students also who have joined up. So when I was a student, I used to make a lot of notes. So I would humbly request everybody, don't make any notes. I would want you all to focus or pay attention to what I am saying and what is there on the slide. There is a lot of content available already online, which you can read about whatever I will show over here. So don't prepare notes. The only thing which you should be noting down is the questions. And I know that there would be a lot of questions because this field is very new to a lot of people. So to save time and plan up things better, we have made this whole session split into two. So there would be a subsequent session which would be happening probably a couple of weeks next. So I'll try to take some questions towards the end of this session. But if there are any questions which are left, there would be a full-fledged 30 to 35 minutes question and answer sessions which would be taken up in the next following up session which we would be having. Okay, so I think probably since I've set the context, so I'll just move to the field of patents. But before I really move into or dive into field of patents, I just wanted to make people aware of certain very interesting things which they may or may not know. But once you read about these things, then probably you would think about in terms of patents. So we all use Google, right? And Google has its very famous page ranking algorithm. So whatever searching we do on Google, the basic algorithm behind that, which was first developed, was the page rank algorithm. And it was basically developed by, its founding members, Larry Page and Sergey Brin. So I'm sure many of us would not be aware about, that the first patent for the page ranking algorithm was assigned not to Google, it was assigned to Stanford University, because Larry Page and Sergey Brin were actually studying at that time in Stanford University. So the assignee, when I say assignee, it means the owner, the first owner of that. Obviously, later on, they started Google, and the patent was further assigned from Stanford University to Google. But in return of that, they received a hefty amount of shares. So they almost received, sort of 150 or 160 millions of, 1.8 millions of shares of Google stock. So think about in terms of the monetary benefit which Stanford University would have leveraged out of that. In current scenario, what would be the cost of that Google stock? And they have 1.8 billion stocks of that Google. Another interesting story which I would want to tell about patents is, if you know Microsoft, many of the patents which are related to Android platform, which is being developed by Google, are actually owned by Microsoft. And they, till 2018, they almost earned $3 to $4 billion of patent royalty fee from Android manufacturers. In other words, whatever Microsoft was earning by selling its Windows operating system, Microsoft actually earned more than that based on the royalties which they received from the Android operating system. And for every Android phone which was sold in market, they were getting somewhere between $5 to $15. So think about in terms of how much revenue Microsoft would have generated from its basic patents on Android technology. Similarly, there was a very famous lawsuit between Samsung and Apple. So lawsuit is something where a company develops its patented technology, but that company finds another company who is basically selling out products, selling out solutions which are actually similar to the patented technology of the previous company. In such a situation, that company can file a court case and a lawsuit in a court saying that these companies are using my technology, so they either have to license my patent and pay me some money, or otherwise they have to do some settlement, some sort of settlement. So the similar situation happened between Samsung and Apple. So Apple has a lot of patents, design patent on their very famous iPhone model. So for all of their iPhone series model, they have a lot of design patents which are filed. Apple observed that Samsung was using or selling some of its Samsung phones which are similar in design to what Apple has patented. Apple filed a lawsuit on Samsung. It was a very long running lawsuit. Towards the end, it is, the amount is undisclosed, but it is somewhere around $600 million to $1 billion. That is what Samsung has to pay to Apple, just because of the fact that Samsung never patented or design patented its designs, and it somewhere infringed on the design patents of Apple. Another interesting thing which I would want to mention is, we all know a company, Qualcomm. It's a very big company. It manufactures a lot of chips which are used, networking chips which are used in the smartphones. Being such a big company, 74% of their operating revenue comes from patent licensing itself. Only 26% of the revenue is from their products or solutions, whatever they are selling. So the whole company, almost 75% of its revenue is only generated based on the patent licensing that they do. So I'm just telling you all these things because people generally think that patent is something which is like a sort of a research paper which we can write and file, but people are very less aware about what patent can really do in real world. There are few more examples. So there is a very big semiconductor company, Marvell Technologies. So they have to pay CMU, Carnegie Mellon University, $750 million because CMU has some patents on hard disk drives, and then CMU basically, they have a very big team of IP. They have a proper team of IP, and they basically asked Marvel Technology to license out their patents, and Marvel Technology basically refused to do so. And when they filed a court case, the Supreme Court actually favored towards CMU, and then Marvel Technology was asked to pay CMU this much amount, which is $750 million. Recently, in this January itself, there has been judgment in favor of a California Institute of Technology. So Caltech basically sued Apple and Broadcom both, saying that they have some patents on Wi-Fi data transmission, which the technology of which is being used by Apple and Broadcom in their products. Apple and Broadcom in a similar way sort of refuse that our products are different. The way we are using the Wi-Fi data transmission in our product is little different. But later on, it was proved that they were actually using the patented technology, and then the court asked them to pay a hefty amount. So Apple has to pay almost $800 million, and Broadcom almost has to pay $270 million. So therefore, I mean, patenting, thinking in terms of patent is really very important. So there has been many case studies, many example scenarios where people have not thought in terms of patent, and then they have faced a lot of disadvantages. On the other hand, there has been a lot of stories, success stories, where people or organizations have thought in terms of patenting their ideas first, and then they have leveraged a lot of advantages out of it. So if you talk about 3D printing, the first few patents on 3D printing technologies, they were issued back in 1917 and 80s. But actually 3D printing was commercialized in late 2000, in a year probably 2010 or 2008. So think about a situation where even in 1980s, they thought about that technology, they patented it, although they were not able to actually commercialize it in terms of a product, or maybe the industry never recognized it to be a very fruitful product. But now when they really, companies like HP or many companies who work on 3D printing, now they realize that they can't patent a lot of things on 3D printing because there has already been a lot of patents which are existing. So they either have to license it or find an alternative solution. GoPro, many of I think the students, young students over here who would be traveling, they would be using a lot of GoPro devices, to record videos when they travel. So GoPro actually, fully commercialized its product in 2009, but the patents related to their technology, related to the that there could be a harness which could be attached to a camera and which could which could still provide you stable images and stable video recording, irrespective of whether you are surfing, climbing, dancing, or doing anything. The patents for these technologies were actually filed by GoPro back in 2004, and now GoPro is almost $1 billion company. So having said all these points, I just wanted to, and there are a lot of case studies like that. These are only few examples. I try to cover university related examples also, so that people start thinking in terms of filing patents and how valuable it could be. So accordingly, patents are really important. So first thing foremost is that if an inventor has invented something, it provides him an assurance of a legal right on his technology. Many a times we see that somebody has invented something, or somebody has worked on something, but his idea gets copied. There is a lot of plagiarism which happens these days. So first thing foremost is that ideally, if somebody has invented a technology or if somebody has worked on something, he should be the real owner of that technology, and patent gives you an assurance for that. So that is the first advantage of having a patent. The second importance of patent is that it is a very important source of scientific and technical literature. Being in industry, I can tell you that I have seen many such examples where big companies, even before identifying what their customers need in terms of a solution, what they first do is they have teams. They ask those teams to see from existing patents in the patent databases for a particular technology, what are the white spaces? What is the current emerging technology? What is the state of the art? What is the current literature which is already available? Where are big companies working towards? So patents in patent databases, they exist and as a lot of scientific and technical literature. You can best correlate it. The students can best correlate it in terms of when I was in college and I used to think about some idea which I can work on for my project, I used to read some IEEE papers. I used to read papers which are on Science Direct. So similar to those databases where people can do their literature study, they can read about what is there in the state of art. Exactly in a similar manner, there are patent databases for each country, and the databases are very well structured in terms of technological categories, in terms of different domains, and it serves as a source for scientific and technical literature. Again, patents really helps in identifying what is the trend of the innovation, what is the emerging technology, what is the state of art. So as an example, we all are facing this pandemic situation. People are really, I mean, everything has changed sort of way. The way businesses are running is changed because of the COVID situation. So a lot of companies have started filing patent applications on the solutions which are relevant for COVID. So if you would have seen that currently in airports, there are solutions which are implemented where you need not to even touch anything or take physical tickets. It's purely based on, you scan a code, the gates would be opened, there are UV disinfectants which are installed everywhere. So all of this new technology which has suddenly emerged in 2-3 months to provide a solution for COVID related problems, there has been a huge number of patent filings which is happening currently. So patent is always about a technology which comes before its actual product. Like the example which I gave for HP in terms of 3D printing. 3D printing, somebody thought of that idea, somebody prepared some basic algorithm steps for doing a 3D printing back in 1980s, but the product actually came up in 2010. So patents are always in advanced version of the technology, and the products always comes after the patents. So it really helps in identifying the innovation trends. Then obviously patents really helps as a value proposition for attracting investments and fundings. So these days many startups they file a lot of patents to attract funding. Even a lot of organizations like IITs, they always build a good patent portfolio to get a lot of funding from government related NGOs, government organizations. Then the basic use of patenting is in terms of monetization, and obviously that you can, like I have given a lot of examples where patents have been licensed, or in a court case there has been a lot of money which has been provided to companies for getting their technology patented. In a way, it is a non-tangible asset for an organization, and it's an innovation driver for a company. So in many big organizations, in many universities also, rewards are being provided to inventors for thinking in terms of patent and for filing patent applications. The reason for that is because of those rewards, because of that innovation culture, innovation comes up in the organization. People start thinking on those lines that whether we can really work on this technology or this area because we would be rewarded. So patent itself is an innovation driver in many companies. Then obviously academic industry linkage. So in my own experience, I have seen big companies like Microsoft, Google. Many at times they don't develop solution or products right from the scratch by their own teams. What they do is they seek out universities, they seek out colleges, or they seek out organizations which are already working on some technology, which are already already having some patents filed on a technology, and then they sort of do a collaboration with those universities. They provide them platform and support to fund filing of their patent application, maintaining of their patent application, and they even hire people from these universities straight away into those project teams which are working on those solutions. So it is a very good platform for providing a linkage between academics and industry. So having said all that, there are some basic things about patent which somebody should know. The first and foremost thing is patent gives you an exclusive right, which means it gives you a right to exclude others from making, selling, offering to sell, using, importing, distributing, or licensing your technology. So as an example, if I have developed an algorithm, or if I have developed a product, or if I have developed a self-driven car and I have a patent on it, so I can stop somebody from making the product which is exactly similar to what I have patented. I can even stop him from selling if his product is mapping or very much close to what I have patented. I can even stop him to offer to sell, which means that there are a lot of situations where somebody would do a marketing of an idea. I mean, that person don't know exactly how that idea would be implemented, but he would go straight away to the customers and say that we can provide a solution for this. Typically, if you talk about in this COVID situation, there are a lot of companies which, because of their brand value, what they're doing is their marketing team reach out to different customers and they say that, okay, we can provide you a solution which somewhere looks like this, but they have actually not developed their solution. Even in such situations, if I have developed that solution and if I have a patent on that solution, I can stop that person to do that. The next thing is that obviously I can stop somebody from using my my patented technology. I can stop somebody from importing that technology, and I can stop somebody from distributing that technology if I have a patent on it. The next thing which is very important about patent is patents are a jurisdiction specific right. So if and this is where a lot of people have a lot of confusions. So if I have a patent for something in India, then I can exercise my right in India only for that patent. Which means that if I have a patent, let's suppose on a smartphone, which has a notchless display screen, which has a screen which does not have any notch, which is a very smooth screen. If I have a patent on that, then I can stop anybody who is selling, offering to sell, making a product in India for that smartphone. But if somebody does that, the same thing in US, if somebody sells a phone in US, I cannot stop him because I only have a patent in India. So patent is always a jurisdiction specific right. So in order to seek, protection on your technology in different countries, people have to file patent in different jurisdictions. Like they file in India also, they file in US also, or probably all such countries where they have a potential market. So there they file the patent applications. Then the next thing is patent is a limit. The time period of getting a right on patent is limited, which means that you cannot get these rights for your lifetime. So if you file a patent application, the right that you can get is only for 20 years for a utility patent. Utility patent is something which is generally in terms of, product or a function or a method or a process or something like that. Then there are design patents also. I'll talk about utility patents and design patents in a few moments later. But that time period for which we can exercise these rights is only 20 years for utility patents and 15 years for the design patent application. And this time period also starts from different dates. So for a utility patent, which means for a patent which I have filed for a functionality in a device or for a end product, for that, the 20-year period starts from the date on which I have filed that patent application. For a design patent, the 15-year period actually starts from the date on which that design has been granted by the patent office. So these are the timelines which are generally related to patents, the rights of the patent. After the expiry of this period, the rights get terminated. So after 20 years, I don't have any right on my patented technology. It is being provided to public, open to public. So so anybody can use that technology. I'll just take a pause for a second. If there are any questions, you can post it on the, I think chat box would be there. So you can post it on chat box.
Sparsh, a clarification.
Yes,
Hello.
Sir. Yes, sir. I can.
For the utility patent, did I hear it right when you said that 20 years from the date of filing of application?
Right.
And for design, it is from 15 years from the date of award of it.
Yes, right.
Okay.
Yes. Right. I think somebody has raised a hand. Anupam, do you have any question?
Anupamji, you can post your question in a question and answer section. I'll actually moderate the questions and we will have
sure.
answers for it.
Okay, and I think it would be good if we can take the more questions towards the end of this session.
Sure.
So now first and foremost things for getting a patent is a patent can only be granted for something new and inventive. I will discuss these two things in a lot of details later on, but when I say new and inventive, new means something which is new, not known to anybody. So if you think of an idea, or if you think of something for which you want to file a patent application, you have to make sure that it is not known to public, which means there should not be any research paper, there should not be any blog, there should not be any video, there should not even be any image, or that technique or idea should not have been known to be used by somebody before you actually file a patent application for that idea. So this is very important, that it has to be new, it has to be inventive. Now what I mean by inventive is it has to provide some technical advantage in the state of the art. So I'll discuss about this in more detail. I mean, these are little complex terms in terms of patenting, but these are the two basic things which one has to consider when he has to think about filing a patent application. Now, as I said that, patents are generally majorly of two types, like utility patent and a design patent. Utility patent is basically, whenever I say patent, or in common language, whenever we talk about patents, we generally refer to utility patents. These are the patents which are, related to a function, a method, an algorithm, a product, a device, a component of a product. For all those things, basically it's a utility patent. Design patents are something which are related to designs, which basically is nowhere related to a functionality, but it is related to how a product looks like, the appearance of that. That is a design patent. I'll show you some examples of utility patents and design patents so that you can understand it more. Then there are a few other patent types which are available in different countries, like standard essential patents are there. So standard essential patents are generally those patents which covers the standards. So for example, if you talk about patents which are related to 3G technology, now 3Gs are standard. So those patents generally comes under a term which is called as standard essential patents. Then there are utility models in China, which are not exactly like patents, but they provide a lesser level of rights to people who file out utility patents. Similarly, there are standard patents which can be filed in Australia. So they also are not majorly like patents, but they provide some lesser level of rights and leverages in terms of a patent to people, and they are also less costly to file. So now coming to some basic things which are related to patents. Before that, I think so. This is how a patent looks like. Many of you would have not seen how a patent on the face looks like when it gets granted. So the final document which after a grant is something like this. So the image you see on the left hand side is basically a granted patent document image in US, and the one you see on the right hand side is basically a granted patent document image in for India patent. Now let me straight away show some example of patents. Okay. So, Sonal, is my screen visible? All right. So this is an example of a patent which Apple has filed. It is a patent related to AirPods. If many of you know, like we use AirPods these days, which are like earphones. So this patent is actually related to a case of the AirPods. So if you see this image, I'll just do it. I think it will take up some time to load, but this patent is a utility patent, and it is filed for a functionality which is basically, it's a case of a AirPod, and this case is basically having a housing and connectors and a lid sensor, but the functionality is that as soon as you open the lid of the case, automatically the AirPods would be paired over a Bluetooth or a Wi-Fi connection to my smartphone. So this is the functionality which this patent is trying to claim. So you can think of, so this is one example, and Apple almost patents everything in terms of functionality before it launches it in a product. So this is straight away a patent related to that function, the case functionality, the case holder functionality of Apple's AirPods. Now, there are a lot of things which are related to this patent and how a patent looks like. So patents it's more or less similar to a research paper which we all write, but there are different sections. So there is an abstract which is very much similar to if you use written IEEE papers, it is very similar to that. The real part of a patent is the claims. So patent, every utility patent, even a design patent, they have claims which are basically provide you the boundaries of what you are actually claiming. So these claims are actually your rights which are used, which basically defines the scope of your invention, what is really invention you are talking about. And then apart from these claims, there is a description section in the patent, which basically describes how all this technology works. So you see there is a summary section and then there is a description section. So the description section basically is the description of the, how you would implement that functionality. So how somebody would have really implemented this technology, those details are actually described in the description. And these details are described with the help of figures. So there are a lot of figures which you can see. So I mean, there are drawings which are there. So these drawings are generally used to describe, very specific, all details, even, to the hardware level and to the software level of these details related to the functionality of the case. So this is an example of a utility patent. Then for every patent, once you file a patent application, it gets published. And once it gets published, you get a publication number. So there are different unique numbers which are associated to a patent. So what you see on the screen at the top, this is the granted patent number. It is a unique number which basically recognizes this patent. If you see over here, there are the names of the inventors who have filed this patent application. But there is an assignee which is Apple. So assignee actually means the owner of that patent. So probably these inventors would have been working in Apple and they would have developed this idea, but the patent is filed by Apple and all the rights of this patent are actually assigned to Apple. Then there are, different basically terms which are more related to patents, which is like, it gets granted, it gets published, which I will talk about now. If you see on my screen now, this is an example of a design patent. So this is a patent again filed by Apple for a design or an ornamental look of the very famous iPod, the music player devices which a lot of us would have used. This is a design patent on iPod. Similarly, this is a design patent on another version of the iPod, which later on came. So think about in terms of, that as soon as they plan to launch a new version of their product, they are also filing a design or a utility patents on that concept. Again, I'll show you some more examples. Just a second.
So what all do you describe in the design patent?
So in design patents, generally it is about how the design is looking and or appearing. So if you see, this is a design patent on the iMac, the desktop which Apple is selling. So it is the look and appearance of that design which they have prepared for a product. Many a times the product is sold because of its unique design and not because of its functionality. So design patent is to protect those designs as such.
In the description or in the claim, is there
Yes.
text related to claim and description,
Yes.
etc.?
Yes. So in design, there is no description as such. The description of the design is the drawings itself. The claim of the design is what you see over here. So there are generally in design patents, you would see a drawing in two form. Some portion of that drawing would be solid lines and some portion of that drawing would be dotted lines. So the solid line is the claim of that design patent. So if you see on the screen, in this first figure, this part is the solid line and the lower part is the dotted line. So they are claiming this screen as the first claim.
So there is no text in the application, in the
There is
design
no text.
patent.
Yes, there is no text as such in the design patent because design patent relates to ornamental design or look and appearance of something. Text is generally present in the utility patent, which I showed over here for Apple's, AirPod case functionality. I'll show you another example of a utility patent. Yes. So this is a patent filed by Microsoft on their Xbox Kinect functionality. So if you are able to see the drawing, there is a person who is standing in front of an Xbox or a Kinect sort of a device. And this patent is a technique for estimating a pose of a body. So this patent talks about how the device works to basically identify the pose of a person and accordingly use it in a gaming application. So this would have a lot of description and technique, how they are doing it, how they are doing image processing, how they are playing with the pixels. So all of those details are described in this utility patent application. So these are a few examples which I just wanted to share for patent. Then how you can search for patent? You can search for patent on Google Patents. So basically it's a search engine which you can simply use to basically search for Google patents. So you can simply type Google patent search and you can then use a lot of terms for which you want to search on a patent. So for example, if you want to search on a patent related to a smartphone with a sort of a very thin bezel, so you can use those terminologies as keywords and then search it to basically look out for patents which are related to that. You can even search on patents on various patent databases like US. This is the patent database for US patent office. So you can use this patent database to search for patents. Then even Europe has its own patent database. So you can search this for searching for patents which are European patents. Now, having said all that, and there are a lot of terms which are related to that patents, and probably I can discuss it about more in the subsequent session when I would be talking about prior arts and all those things. But this, I just wanted to give a basic idea about how a patent looks like and what are the types of patents generally. Having said that, a lot of patents which are there are not generally used. So there are a lot of useless patents which are being filed by people, and those patents are even granted. So here are some examples of that. So somebody filed a patent on a mustache guard. Now this is of no use, and this was actually granted by US Patent Office. It is even expired also now. 20 years time has crossed now. Somebody filed a patent for a method of swinging a swing. I mean, we have been using swings in parks for so long. Somebody filed a patent for a method of swinging a swing, and that patent was granted by the patent office. And I mean, this is for no use. So not all patents are valuable. This is something which I wanted to emphasize on. If you see this, somebody filed a patent and called it as a beer umbrella. So it is a case holder with an umbrella for holding a beer bottle, because he thought that when he takes it out from the refrigerator, it is not chilled. So to protect that from sunlight, he basically designed this umbrella and a case holder. Similarly, there is another patent which somebody has filed, which has a pillow with a umbrella which could be retracted to protect him from sun rays when he is sleeping. So I mean, a lot of patents are generally filed, and there are a lot of crazy patents. So you can search. I mean, and you can see a lot of crazy patents which are being filed and even granted by patent offices for different purposes. So that doesn't mean that we can file a patent for everything. So having said that, we have to critically analyze that what are the things for which we should actually file a patent application, and that is something which I will be discussing in subsequent slides. So this is a basic structure of how the patenting system looks like in India. So I mean, the Controller General of Patents and Trademark Office, this is under the Ministry of Commerce and Industry, and under which we have our patent office. There are 4 patent offices in India currently, in Kolkata, Delhi, Mumbai, Chennai. And then there is a trademark registry which is there. So basically someone can approach and file the patent applications in these offices. Now, this is a patenting system timeline in India. So think of a situation where you are a student or you are someone who has conceptualized or developed some idea, who starts to think that whether I should file a patent application or not. So what are the stages at which he would move ahead? That is something which I am trying to explain over here. So somebody thought of a problem which he should solve, and then he thought of a solution which could be there, which he can implement. And then he basically conceptualized that idea, and then he basically reduced it to practice, which means he developed some prototype of that solution. Now, reaching to that stage, he got some confidence that, okay, I can file a patent application on this idea. So he contacts somebody who is called as a patent agent. Patent agents are generally authorized to prepare a patent application, file a patent application in patent office. and then he files a patent application in India. So when he files a patent application in India, automatically by after 18 months, that patent application gets published, which means anybody can see it on a Google patent. Anybody can, that patent is available for public review and visibility after 18 months. So the life of patent actually starts from the date on which you file the patent application and till 20 years. But you can exercise your rights against somebody from the date at which the patent is published. Meaning that if you file a patent application and it gets granted, then you can sue somebody for his use of your technology from the date after the date of getting it published. As an example, if I file a patent application in 2018, it gets published this year in 2020, then this year onwards, if somebody is making a product on my technology, then I can sue him. Condition that my patent should be granted. I cannot sue somebody for a patent which is not granted. So after the grant, I can sue somebody. Then the patent is published and then it is open for examination. So generally in patent office, there are patent examiners who examines your patent applications against a lot of things. They examines that whether your technology or whatever idea that you have for which you have filed a patent is new or not, whether it provides a technical advantage or not, whether it falls under the any of the statutory categories which are not patentable in India. And based on that, the patent office generally issues a report which is called as a patent examination report. And in that report, there are generally rejections, objections which the patent examiner may have related to your idea, and then you have to overcome those rejections and or do certain changes to the description of your patent application as in required by the examiner to get your patent granted, and then the patent is granted after that process. Now, sometimes the examiner also calls for a hearing, which means that after issuing his first report of rejection and receiving your response to it, he can call you up in the patent office, he can discuss your idea, and then he can put forth his view or opinion. And then based on that discussion, he would ask you to make certain changes to the description of the patent application. And then accordingly, you can make those modifications and then the patent gets granted. So these are certain basic things which are related to patent. In terms of the patenting system in India, we have patent office, which generally deals with, where we file the patent application, which grants the patent application. Sometimes, the patent examiner does not grant the patent application. He may issue a rejection to your patent application. So you get a chance to basically appeal against his decision. You can appeal that, I think that based on my understanding of the invention and technology, this should have been granted a patent. And you can reach out to Intellectual Property Appellate Board, which is a appellate board at a status higher than the patent office. And then you can file a request over there for an appeal. And then in certain situations, the examiner's decision may be overturned and it can be in your favor and you can get a patent grant. Then above that, we have High Court, which is like General High Court, which we have in India. So typically for any cases which are related to patent infringement, those cases are generally heard in High Court. So High Court pass a ruling on generally infringement related cases in India. And then we have Supreme Court for only for certain situations. Somebody can reach out to Supreme Court and fight for his case. Okay, now there are two routes for patent filing in India majorly and even across world. So one is under Paris Convention and one is under Patent Cooperation Treaty. So the Paris Convention route is something where you can first file a patent application in a convention country. Convention country is like India is a convention country, US is a convention country, Europe is considered as a convention country. So all those countries which are part of that Paris Convention are considered as convention country. So this is the first way of filing a patent application, where you can do a first filing in a convention country, and within 1 year of that you can file a patent in another country which is also a convention country. So for example, I can first file my patent in India, and I can within 1 year of that filing, I can file a subsequent patent in US or in Europe or in Australia or in China, any other country. Similarly, there is another way of filing a patent application, which is a PCT route, which means that you can file a patent in a WIPO, which is like World Intellectual Property Organization. It is called as a PCT application. So WIPO basically covers all the patent jurisdictions, you can say it in a way. So many countries are a designatory of WIPO. All major countries are basically designatory of WIPOs. So you can first file a WIPO application, which is a PCT application, and then you get 30 to 31 months of window. You can wait. I mean, many a times it happens that somebody is not very sure of that whether I have to file a patent application in all countries or not. In such situations, companies or universities generally follow this route where they first file a PCT application so that they can get a 30-31 month window. They can make a decision even after 28 months, and then they can file in any designated countries like US, India, Japan, or China. So these are two major routes by which patent filings are generally done in India or across organizations. So having described a basic, basic idea of what a patent is, what are different types of patents, I would want to emphasize on certain things which are related to patenting. So patents are generally granted for something which is new and inventive. This is the first and most fundamental principle of deciding whether we should file a patent application or not. So when I say something is new, as I mentioned, whatever you are thinking of to file a patent application, think in terms of whether it would have been already disclosed in public domain, which means whether a research paper is already there or not on that aspect. So if I am thinking of an algorithm which I can use to improve the efficiency of how my smartphone works, and if I want to file a patent application on that, so I have to first see whether in existing literature that technology is already described or not. If it is there, then in no manner I can get a patent on it. So that is the first and foremost thing. It should be new. I mean, your idea should be new, not known to anyone, not known to public. And that's the reason many big companies, before even doing a marketing of their idea which they have conceived, which they want to offer it to a customer, they first do a patent filing, because otherwise they may not get a patent on it. So novelty or new is something which should be there associated to a product or a process or any functionality for which you want to file a patent application. The second thing is inventive step. Now this is a very, a little complex term. People get confused to it, when they talk about an inventive step. Inventive step is something which means something which is not obvious. So for example, just to give you an example, let's suppose I thought of an idea for filing a patent application, for providing an effective route for somebody to reach from one location to another location. Now I thought of improving the Google Map functionality. So I thought of making an application which is like a Google Map, but which can provide a route which is more effective than the route which is being provided by Google Map. Now the algorithm that Google Map is using basically considers a lot of factors. It considers traffic, it considers the shortest path. Now I thought of considering some more factors which can improve the route efficiency which is being provided to suggest a route. I may not get a grant on that patent. The reason being is, it would be very easy for somebody to basically pull out the functionality of Google which is available, or pull out the algorithm of Google which is available, Google Maps which is available, and pull out another document or a research paper which talks about a route optimization algorithm which considers many other factors other than what Google Maps is considering. Now an examiner who is examining your patent filing application, he can basically see those two documents and say that it is pretty much obvious for somebody to include some additional factors for improving the route which you are suggesting. In such situations, he would not allow you a patent application. So your idea has to be new also, but it has to be inventive also. So continuing with the same example, if suppose I develop an application to provide a map, it's an application which provides a map or a route for somebody, and I say that this route is different than the route which is provided by Google Maps. So I would say that my algorithm is different. I am not using the algorithm which Google Map is using to suggest a most effective route to reach, let's suppose from my home to office. My algorithm basically considers a lot of added factors also, a lot of other factors also which can improve the route which I am suggesting. So yes, my idea is new. I mean, nobody thought of that. Even Google Maps was not considering that algorithm. First parameter is okay. I mean, the idea is new, so yes, I can think about a patent filing. But if I can prove to the patent office that the route that I am proposing is an effective route in terms of that it provides a technical advantage to the systems that I'm using, then yes, I can file a patent application. application. I should file a patent application for it. For example, if I can say that the route which is proposed by my app, which is very similar to Google Maps, is something where there are no slopes, there is no bumpy roads, it is less accident prone. It basically, when my vehicle moves along that route, then the fuel consumption that my vehicle has to undergo is very, very less than compared to the fuel consumption that I had to undergo when I was using the route which was provided by Google Maps. In such situations, if I'm able to prove that yes, I am basically providing an advancement in the technology to the existing systems, then yes, I can file a patent application. I should file a patent application for that. So this is the first and foremost thing which people should understand when they think about filing a patent application, that your idea should be new. In simple words, you can first do a basic Google search, or search on YouTube, or search on Google Scholar, or search on Google Patents also, that whether something very similar is already existing or not. If something very similar or exactly same is existing, then the chances of getting a grant on your patent should be very low. Second thing is obviously inventive, which I mentioned, that it should be technical. Your invention or idea should be technical in nature. It cannot be a non-technical idea, and it should provide some advantage to the existing state of the art. Now, the other thing which many of us should also consider is to differentiate between invention and innovation. A lot of people do innovation. That doesn't mean that it is an invention. When I based on my experience working in product companies, I have seen that there are a lot of engineers who would develop very effective solutions, who can develop solutions which improves their existing product line or existing techniques which are already there, but they are not able to get patents on a lot of such solutions. The reason being, we call it as innovation. It is not an invention. Invention is something which is legally defined by a patent act in India, and even patent acts which are available in other countries also. So as an example, you should first think whether your idea is an invention or whether it's an innovation. So now, what is an invention or what is not an invention? So the good thing in India is that, unlike US, in India we have a negative list. We have a list of what does not fall under a category of an invention. I'll just take a pause over here. Sanjay sir, I think we've crossed 1 hour. We have time. Can we extend it to 10-15 minutes if it is possible?
Yeah, sure. Please do.
Sure. Okay. So yes. So this is a negative list which anybody can easily see to understand for what all things he cannot file a patent. He should not file a patent application, because this is by law not patentable. These are the categories which are non-patentable subject matter. First is an invention, primary or intended use of which is contrary to law or morality or public health. So for example, if you develop a device to do a theft, you cannot file a patent for it, because it is contrary to the morality, it is contrary to the public health also. Similarly, you cannot develop a device and go for a patent filing which is for a gambling application. So that is an idea which is contrary to the law. Gambling is not allowed in India. So you cannot develop a thing and you can go ahead and file a patent application on this idea. Then the second category is a mere discovery of a scientific principle. So for example, if based on something which you were exploring, you discovered an existing scientific principle, then you cannot file a patent application for it. For example, if you implemented some integrated circuit and sort of proved the Kirchhoff law, you cannot go ahead and file a patent application for Kirchhoff law, because it's an existing well-established scientific principle. So a discovery, for discoveries, you cannot file a patent application. It's a non-patentable subject matter. Again, something which is frivolous also, you cannot file a patent application for it. For example, if somebody developed a clock which has a dial pad in which each hour is divided into 100 minutes, you cannot file a patent application for that. An hour has 60 minutes. So that's a non-patentable idea. Then the mere discovery of a new property or a new use for a known substance, you cannot file a patent application for it. For example, if you talk about something which is like say hydrochloroquine. So we in this COVID situation, we have heard a lot about HCQ. Now HCQ was generally used as a immunity booster. Now, somebody cannot file a patent application on saying that I'm using HCQ to treat COVID. Whether he is able to treat it or not, that's altogether a different story, but you cannot file a patent application for a new use for a known substance or a mere reuse of a known process. Again, you cannot file a patent application for mere rearrangement or arrangement or rearrangement or a duplication of a known device. So, as an example, what I could suggest is that you cannot file a patent application where you can say that I have developed a bucket which has a torch in it, because I'm not able to see in my bathroom when the light is not there. So you cannot file a patent application for a bucket having a torch, because it is nothing but a mere rearrangement of two known devices, and it is even giving the predictable result that if I install a torch in a bucket, it would give me the predictable result. So that is another category for which you cannot file a patent application. For method of agriculture and horticulture, you cannot file a patent application because these are generally covered under Plant Protection Act in India. Anything which is related to atomic energy, you cannot file a patent application in India because it comes under Atomic Energy Act. So you cannot do a patent filing for that. And this is something which is more interesting for students like us who are generally there in engineering college. You cannot file a patent application for a mathematical formula. You cannot file a patent application for a business method. When I say business method, you cannot file a patent application for a banking transaction system unless you write the patent application in a way that it sounds more technical, it has some technical aspects related to it, and the claims are not claiming a business method. You cannot file a patent application. You can file, but it would not be granted. You cannot get a patent grant on a mathematical or a business method. Computer program per se. Now, this is something which is very much discussed in patent industry in India. It is it is because we have a lot of computer development programs and coding platforms which are available, software development platforms which are available. Coding something is not a big task now. You can automate a lot of things by writing a software code for it. So purely for software code, you cannot get a patent. So computer program per se is not patentable in India, but that doesn't mean you cannot get a patent on a software. If you have written a code for something, or if you have developed a prototype for something, it has to bring up something more than merely a code which automates something. So I'll discuss some examples where it could be proven that you can get a patent application for a software related invention which is more than merely a code. Then mere scheme or rule of method of performing a mental act or a gaming, you cannot get a patent. So in India, it is very difficult to get a patent application on a gaming application. So, but that doesn't mean you cannot get a patent application on Kinect or Xbox. That is a hardware device. You can write a patent description where you can describe how you are capturing 3D images, where you can describe how you are actually doing image processing to actually estimate the pose or the appearance of a person. For that part, you can get a patent application, but for purely a gaming application, you cannot get a patent application in India. Presentation of information. So if you have seen, if you want to say that I am presenting information in a unique manner, for that you cannot get a patent application in India. Which could be like if you've seen that different Windows have their own way of presenting icons or tile structure. If you have seen on Nokia phones. So in India, it is difficult to get a patent application on mere representation of information. But in certain situations, you can get a patent on that, but you have to prove that it provides some sort of a technical advantage to it. So if, for an example, I can say if all of us who are using Android phones, there is a feature to basically group a lot of applications in one folder. So, on a user interface, we have a feature where we can club a lot of icons of patent applications, icons of a lot of mobile applications into one folder depending on its functionality. For that, I can file a patent application because it is providing me an ease of use. It is providing me, a short. I can use my phone for a lesser amount of time compared to what I would have traditionally used. So if I say those arguments, then I can probably file a patent application in India. For a topography of integrated circuits for electronic students, we cannot file a patent application in India. That's a non-patentable subject matter. Traditional knowledge. This is again something for which you cannot get a patent grant in India. So for example, if you say that I will file a patent application of using turmeric as a healer for an injury, you cannot get a patent application in India because that is there. I mean, that is known as a traditional knowledge in India since a long time. So in US, somebody filed a patent application for using turmeric as a for healing an injury, but that patent was later revoked because somebody from India mentioned that this is there known in India since long. It's a traditional knowledge, so nobody can get a patent on it. So these are some of the negative list or categories of non-patentable subject matters. So as a innovator or as a thinker, we can think if our idea is falling into any of these categories, then probably it would be a difficult situation to get a grant of a patent application in India. Again, I think I discussed about novelty and inventive step to some details. In probably the next session, I would be discussing more about these details, like what is a novelty, what is inventive step, how you can do a prior art search to quickly see whether you can actually file a patent application or think in terms of filing a patent application in India. Some other things which you should also consider in terms of filing a patent application in India is whether my idea is workable or not, and this is exclusively for India. So in India, inventor has to, after getting a patent grant, he has to also show the working of that patent, that whether he would have actually implemented that in in working or not, or he's able to implement it in working or not. So if my invention, if my innovation is something which is merely at an idea level and I don't know how to implement it, I don't know how to really make it into an implementation, probably it would be difficult to file a patent application for it. Mere ideas are not patentable. But yes, if you don't implement it actually as a prototype, but if you know that these are the steps which I would have to do probably to implement it, and if you can provide those details in a description of a patent application, then yes, you can file a patent. You should file a patent application of it. So having said that, one thing which everybody can consider for deciding whether they should think of a patent filing or not is whether they can enable that invention. When I say enable that invention, means whether they would be able to describe at least those level of details in a patent description, that if somebody in that field of work reads those level of details, if he would be able to develop a solution on that, then probably you can file a patent application on it. As an example, if Sanjay sir works, let's suppose, in field of image processing or graphics, computer graphics, he knows that technology. And if I as a student think of an idea where I can do I can work towards some idea which is related to stitching of 2D images and creating a panoramic image out of it. I have not developed a complete source code, or I have not coded that whole solution into a prototype, but I know the algorithms which I would be using. I know the changes that I would be doing to that algorithm to implement that solution, and I am able to describe it in a patent description, so that if Sanjay sir reads that patent and he is actually able to develop that solution using his own knowledge, then in such situation I can file a patent application in India. So I only need enablement details which are sufficient enough to basically go ahead and do a patent filing in India, and there are chances that I can get a patent granted in that. Other aspects which I think students and even faculty members should consider in thinking about whether they should go and file a patent application in India or not is, does your idea relates to a disruptive technologies? I mean, if you are working on something which is altogether a disruptive technology, certainly you should go ahead and file a patent application over it, because the chances of somebody already filing a patent application on that thing would be very low. The chances of some research papers or public literature available on those lines would be really low, and there is a high chance that you may get a patent grant on it. Like self-driving cars. I mean, if you are thinking on those lines, then I don't think that there would be a lot of content which would be available for self-driving cars. So if your idea is a disruptive technology altogether, think on filing a patent application on it. If your idea is merely an incremental idea, if you're developing something which is a route optimization algorithm or something which can improve the routing for routing app, that is something. I mean, I would not suggest somebody to invest a lot of cost in doing a patent filing, because there would be a lot of literature already available out, which would lead chances of getting a grant success in your case really, really low. Again, the third point could be, if your idea is something which can attract startups, which can attract government projects, product companies, certainly go ahead and file a patent application for it. I've seen a lot of tie-ups which happen between universities and industries, just because of the fact that those universities are working on those lines, which the industry likes, or for which the industry has some solutions or offering. So consider a company who works in a warehouse related domain. So if the university is working and providing some solutions which are related to warehouses, then obviously that company would be interested in doing a tie-up and engaging with the students and see if they can use part of their technology. And in such situations, universities even get funding from those companies and full support for filing a patent application on those ideas. So if your idea is something which can attract startups, which can attract government projects, product companies, certainly you can go ahead and think about filing a patent application on it. Then detectability is again something which I think is valuable. So if you think that your idea is very much related to a backend sort of a thing. So for example, if your idea is very much in terms of a machine learning algorithm which you are implementing, or sort of a neural network algorithm which you are implementing, which would be difficult for somebody to see in a product, which means that if somebody reads your patent and implements that whole algorithm or idea in this product, it would be difficult to detect whether he is actually using your technology or not. In such situations, patent filing is not generally favorable. Patent filing should be more for areas where you are working on something which could be seen, which could be detected in an end product, for which you don't have to do a tear down sort of an analysis or completely read a source code or do reverse engineering to understand if he's using the technology of your patent. In such situations, if the detectability of your idea is very high, then yes, you should think about filing a patent application on those lines. So these are some of the points I think which I wanted to focus on in terms of doing a self-evaluation of whether you should file a patent or not. Then there are experts, which are patent professionals like me, who can then provide you further assistance in terms of whether you should go ahead and file a patent application on those lines or not. But these are the certain points which somebody can use to do a self-evaluation or assessment of the filing a patent idea or not. Having said that, this is the agenda for the next session, and just wanted to give a brief overview of that. And I would be talking about, particularly for students, what is the career in IP? If they want to pursue a career in intellectual property, what all things they have to do in terms of the work, how is the work like, and what are the traits which should be there in somebody to actually go ahead and pursue a career in intellectual property. I would also be discussing some examples of failed attempts to get a patent grant. We all read about success stories of somebody getting a patent filed or granted, but there are very interesting examples of failed attempts of getting a patent grant. And this is more important because patent filing involves a lot of cost, a lot of efforts. Not even filing, preparation of patent application requires a good amount of cost. Filing a patent application requires a good amount of cost. It gets almost 4, 5 to 6 years minimum to get a patent granted. In India, it is particularly, the average years is like 12 to 13 years after filing a patent application that you get an actual grant. So it should be a very subjective decision. It should be a very critically scrutinized decision before somebody should go ahead and file a patent application. But having said that, that doesn't mean that somebody should not file a patent application, because in universities and in organizations like where a lot of thinking happens, I have seen very creative ideas which are being discussed, and people had simply submitted a research paper on those ideas, and the moment you submit a research paper on an idea, you can never file a patent application on it because you have published it in public domain. So you can file it within 1 year of publishing it in public domain, but probably you can, the chances of getting a patent over it goes really, really low. So therefore, I think I would like to conclude over here. Yes, one more thing I wanted to show to people is, particularly to the students of the university, like if you are in any of these categories, you can think about having a career in IP. So in building a career in intellectual property requires reading a lot of patents. So on an average, I can tell you someone has to read about 5 to 10 patents and understand in full detail on a daily basis. So if you are not a technology reader, if you don't like reading research papers, If you don't like reading as such, don't think about pursuing a career in IP. If you like to read, then certainly. If you like to write, and then also you can think about developing a career in intellectual property. If you're good in analyzing and presenting data, then yes, this is a field which is for you. If you want to work in a job which requires strategic thinking, which requires business analysis, which requires research and analysis, then this is a field which you can look up, and this is the right time for students who are in their third year to think about pursuing a career in intellectual property. If you find interest in legal topics, then yes, this is something. The job is purely a techno-legal job. It is an amalgamation of technology and some level of legal concepts. It does not require a full legal knowledge. I mean, you develop a legal knowledge over a period of time, but it does not require a knowledge equivalent to a lawyer. It requires you to have a good technical knowledge and some interest towards legal topics. So yes, I think these are the things which should be there. And yes, I mean, for a student like me who was little resistant towards coding, I was a software engineer, but I always used to face challenges in developing a software code or a prototype. This is an area which you can at least think about in terms of developing your career in IT, because you still are very much reading and into technology, but you are not actually developing a code. But that doesn't mean you have to understand. Career in this intellectual property requires people to interact with engineers who are product architects in their field, who are fellows in their field, who are developing some solutions since past 20-30 years. So you have to interact with those people, and those people are very busy. So you just get a very limited amount of time to understand the technology. So if you are not good in developing something, in coding something, but you are good in understanding the technology, then this is a field which you should look up for. So that's all. I think I think that time was little constrained, but we anyhow have 2 sessions. So I'll cover a lot of things which I was not able to cover in this session in the next session. The last things which I would want to say is that for students particularly, like, look around for technical problems which are available, which you can solve. And the moment you think of a solution, think of whether you can actually go ahead and think of filing a patent over it. And to tell you, like, patents are not for individuals. Even in a group, people can file a patent application. So there are patent applications who has even 40 inventors listed over it. So 40 inventors work together on an idea and they file a patent application on it. So even if you're working in a collaborative work environment, you can together file a patent application for it. So that's all, I think, for this session. Probably in the next session, we would have some more interesting things to discuss.
Thank you so much, Sparsh, for this informative session. It would really help us a lot. But before we wind up or we conclude, there are certain questions in a question and answer section. Anupam ji has been asking that from where we can get existing literature on patents.
Okay, so this is a very good question, I think, and a lot of us ask these questions. So as a person who is not very much into patenting field, the first and foremost touch point should be your Google patents. So just like you open Google Scholar, you can search in Google for Google patents, and you can basically perform searches for some, in a similar way that you search for something on a Google, you can do a similar way searching for patents on Google patents, and you can get a lot of patents over it. So I'll quickly show you an example so that it becomes a little easy. Just a second. So I have typed Google patent. Are you able to see the screen, Sonu?
Yes, yes.
Yes. So I have typed Google patent search, and I open this, and Google. This is the search engine for Google patents. Now, assuming that I want to search for a patent application on a, let's say, for example, self-driving car. So I'll type self-driving car, and then I can use this plus sign. This is nothing but a AND operator, and I can, write about a particular thing which I'm trying to search in that self-driving car. So for example, if I'm searching for self-driving car along with an Internet of Things related application. So when I do a search on it, so the results that I'm getting, these are basically talking about, autonomous vehicles, autonomous mode of bimodal vehicles. So it's a simple way to do a search for patents which are there in, Google Patents. Now Google Patent has its advanced patent search tool also. I'll show you that. And these are freely available. So you can use these platforms to do a patent search. So this is how an advanced patent search tool of Google Patent Search looks like. So in this, basically, you can provide a lot of things. Just give me a second. Yes. This one. So let it load. Yes. So if you see on the screen, it provides you a lot of options, not even just to write keywords, but a lot of other things also to do a search. So for example, if I talk about, let's suppose pose estimation related patent, which is filed by Microsoft. So in assignee field over here, original assignee, I can write Microsoft. And when I would search over here, I would get the patents which are filed by Microsoft and which are related to pose estimation. So, and this altogether is a topic which would require almost an hour or so to effectively search and find out results. But just to give a small answer for this is a basic technique which somebody can use to search for existing patents. And when I talk about existing literature, you can even search for open literature like IEEE papers or Google Scholar. You can search on those also.
We have few other interesting questions. Can people copy patents from other countries? Is it authentic?
No, it is not authentic. So copying is never authentic. By inherently, it is never authentic. So if you copy somebody's patent and do some tweaking over it and think of filing a patent application in India, almost 50% chances are there that when you file that patent application in India and it is examined by a patent examiner, he would bring that patent to you in his examination report and he say that, see, this patent is already there in US. So, and that chances are very high because the tools which are used by patent examiners in patent office are far, far advanced than the tools which a normal person would use. The tools which we as patent professionals use have a far advanced searching facility and capability to identify documents which are already there, and people are experts in those fields. So like as an initial stage of my career, I was an expert in doing a patent searching. So my job was to find out if this idea is already existing or not. So somebody who is expert in that field, a patent examiner is way more expert than what patent professionals are sometimes. So he would do a job of 1 or 2 hours and he would be able to give you the same patent from which you would copy the content. So that's not a good idea.
How many views are required? Is this thing related something to this? No.
I think this question relates to design patents. When you are showing, I think Ravi asked this question at that time.
Okay.
Yes.
Okay. For design patents, you can have only one drawing also. You can have 100 drawings also. So that depends. Like, so for example, if I want to, so if I talk about Apple design patents, which I shared. So for the design of Apple's iPhone, they would have filed almost 20 to 30 patents, different patents, granted design patents on it, which claims the design from different perspectives. So, I mean, in one drawing, they would have just claimed, the front screen with a circle over it, which talks about the touch bar that is there on the Apple iPhone. In another drawing, they would claim the view or appearance of the speaker icon, which is over there. I mean, if you see the bottom part of your bezel of the phone, you have some dots of speaker. So they would claim that design. So there could be n number of drawings in a design, claiming it from different design perspectives. So if you see on my screen, this is the design pattern for iMac. I mean, the desktop version of the Mac, iMac, which Apple provides. So it has almost many figures. So see, first figure is basically the front view. Second figure is the back view. And then third figure is another, this type of a view. So there would be a difference between the first figure and third figure. So they would try to claim the design from different aspects. So if you see this fifth figure, it is the side view. So it all depends on like what is the unique part of your design and what all you want to claim. So they have even claimed the side view also. So if somebody is implementing a product which is a design for which the front design is not same as the design of the iMac, but the side view design is same as of this, he would be infringing on this design.
People file the patent but never execute as an application then?
Pardon, Sonal, can you just repeat the question?
People, there is one question from Dr. Sheetal. She has written that people file the patent but never execute as an application.
I'm not sure I understood this question.
Okay.
Execute as an application, does it means that they never implement it as a solution in a product or they never use it?
Yeah, that's what I also believe, because you were also talking about there are certain patents which have never been utilized. I think she's talking about same things.
Yes. So yes, I mean that is true. I mean a lot of patents are being filed. So whenever you file a patent, it is called as a patent application. So the right term to address it is a patent application. When you say patent, it means a granted patent. So if somebody is saying that I have 10 patents and none of them is granted, he is not having any patent. So patent is only called a patent when it is a granted patent. Otherwise, it is called as a patent application or a patent pending. So yes, this happens many times that people file patent application and they don't use it. Yeah, this is a very common.
Yeah, there's one. There are questions, 2-3 questions which I'm combining and asking. Major, it is they are asking about what is the overall cost of filing a patent in India, genuine agents for helping to file a patent in India, and should we think first to file a patent and then publish it?
Yes, so actually these are separate questions in totality. So yes. The cost of filing a patent application, so it is just not the filing cost. I mean, preparing a patent application itself requires a cost, because if someone prepares a patent application which is bad in shape, which is not as per the legal requirements which are there in as per the patent laws, then the chances of getting a success over it is very less. So you need to get the patent prepared from an expert, which requires his professional fees, his cost. Purely if we talk about the patent filing cost and maintenance cost in Indian Patent Office, it would be something around 20,000 to 30,000 or maybe 40,000. But the whole professional fees which is associated with that cost is more. I mean, if you talk about somebody who would prepare a patent application, he may take 50,000 or even 1 lakh rupees to prepare a good patent application. So that depends, but yes, patent and there is a lot of content which is, I mean, the cost is variable. So when you do a Google search and seeing how much a cost is associated with filing a patent, you would see variable results. I mean, there is no fixed cost sort of a thing. The only thing which is fixed is the fee structure, which is provided by the patent office. So like if you and particularly for small entities who are not big organization, big companies, in Indian Patent Act, a lot of options are provided that you can file a patent at a very reduced cost. So as an example, if for filing a patent application by a large organization, you have to pay 5,000 rupees. For a small entity like an SME or a startup, it is almost like 2,000 rupees. It is very less. It is almost 1/4 or even less than that sometimes. I mean, the cost of filing and maintaining a patent application many a times goes around 1 to 2 lakhs rupees also. So it is just not about filing. Once you file a patent application, you also have to pay a fee for maintaining that patent application year on year basis till 20 years of that life. Which is also a fee which somebody has to pay. The owner has to pay. So yes, it requires a good cost. The second thing is regarding the the question regarding the publication. So as I told you, if your idea is published somewhere, if you published an idea, or if you even discussed your idea on a event where many companies were there or many universities organized an event, and you discussed your idea or a project on which you are working to the students of other universities, and they found your idea interesting and they have written a blog over it, then the idea is gone. You cannot file a patent application for it. So that is why it is very important that before you make your idea public, you should file a patent application on that idea. So you cannot publish something before filing a patent application on the idea. And once you file a patent application, it automatically gets published after 18 months of filing.
Okay. Any average percentage fixed for getting the patents granted every year in India, particularly?
Actually, this percentage varies depending on the technology. So, for computer science related inventions, the percentage is very less because the standards are very strict. The inventions are also very much incremental, not something like which is very much sort of a disruptive, which is altogether a new thing which nobody thought of. So the percentage of getting a grant for a computer related invention, purely computer related invention, would be less. Even within one technology. So for example, for a computer related invention, if I talk about neural networks, if I talk about artificial intelligence, these are relatively newer technologies. So the percentage of getting a grant would be little higher compared to if I talk about NLP or speech recognition related technology. So there must be already somewhere around 5,000 patents available on speech recognition technology. So this percentage varies depending on the technology. But on an average, a grant rate could be not more than, I think, 10% or 15% of the total file.
Is there any software where one can check whether the work submitted has been patentable or not?
Yes, I think Google Patents is the software which you can use to check whether your idea is patentable. I mean, somebody has already.
As soon as they grant it, it comes under it is indexed by Google?
Not even granted. After 18 months of your filing, as I said, that it gets published in public domain after 18 months of your filing. So if
18 months duration has to be there. Okay. And if it is actually, it may be granted before 18 months as well, or 18 months are compulsory?
No, it gets granted after publication only. But sometimes.
Same, both utility and design patents, both?
Yes. But sometimes, it is like that, it is mandatory. Sometimes it gets granted before even 18 months, but the moment it gets granted, it gets published. So I have myself drafted some applications which got a grant in 10 months after filing it. But the moment it gets granted, it gets published.
Okay. Let us take one last question. Can you tell something about Australia patents, or why patent attorney is suggesting to file for this country?
I have not worked much on Australian patents, but more or less the patenting systems is similar in Australia as it is in India. I know one thing, that in Australia you can even file a standard patent, which is a low category sort of a patent, which provides you lesser rights, which is the life of which is only 10 years. But I think majorly the patent filings are, that I have majorly worked on US, European, Indian patent filings, because generally big companies have markets in these countries. So they do a filing in Australia also, but generally those things are taken care by people or law firms who are there in Australia. Okay. So like basic patent is prepared for India or US by people. But the same patent is, same documents and everything same is used and shipped to the law firm which is there in Australia, who can do a patent filing in Australia. But legally, law-wise, everything is more or less very much similar. The only thing is that the standards for getting a patent granted in US are relatively easier compared to the standards which are there in Europe. So in Europe and India mostly follows the standards of European Patent Office. So in India also it is little difficult to get a patent granted. In Europe also it is little difficult to get a patent granted compared to getting a patent grant in US.
Okay. Thank you so much, Sparsh, for this entire session. You have actually talked about entire life cycle of how to file the patent and many. Now I think everybody might start thinking, and everybody would wait for your next session, and we would have actually good amount of questions in the.
I would just say one thing, that it is a very vast field. And in one session it is little difficult, and it's a new field for people. So like if we talk about a technical topic, people are little aware of already what it is, but patents is something which many people are not aware of. So consider this session only as a basic session to get some idea of patent. I think probably in next session people would get a lot of insights on some specific.
Before that, they will actually surf the contents of the, at least see the whatever you have conveyed in this session. That would also help. Sanjay sir?
I just want to say thank you. Thanks a lot, Sparsh. It was a wonderful session. And I'm already looking for your next session, and I'm sure many more students should get interested in it. And and aspire to make a career as a pattern specialist, as a pattern searcher or a pattern analyst or a patent expert, or things like that. And we hope that this will, and maybe you can also in your next session share a list of such companies who are active in this area and offer such kind of jobs to freshers in the patent field, and that would make them more excited in this area. And so I just want to say thanks a lot.
Thank you, sir. Thank you so much. And I think thank you everybody for attending this session. I must say as an ending note that this is COVID time, so everybody please stay safe and take good care of your health.
Thank you so much. Thank you, Sanjay sir, for allowing us to host this session, for connecting us with Sparsh. I would like to thank each and everyone in the audience for listening us patiently, for putting good questions. There's few of participants are also viewing you on YouTube. Today we have hosted this session on YouTube, and I think you are the first one whose session has been hosted on YouTube. But till now we have been hosting on Facebook. So now we have inaugurated putting things live on YouTube from you. Thank you so much.
And one last thing is, for all the questions which people would be having, it would be good if you can pen down all your questions, share it to Sonal or Sanjay.